Do not sign a non-competition agreement. The federal government, the state government's not going to come bail you out. If you don't understand what you signed, it doesn't matter. It doesn't matter if you understand it, because if you sign it, you're bound by it. Expect to be bound by it. Again, not legal advice, not your lawyer, not attorney-client privilege. This is a separate piece of things. But the advice is, if you get a non-compete, you can find a better job. You don't need to sign it.
Welcome to Between the Briefs, a podcast by Steno. We share practical tips and expert insights on the pretrial process, court reporting, and legal technology to keep you updated on how technology is revolutionizing the litigation process and the wider legal sector. I'm your host, Adrian Cea.
Hello and welcome to Between the Briefs, brought to you by Steno. I'm your host, Adrian Cea, and today we're diving into the world of post-employment restrictive covenants with a distinguished guest with expertise, bridges legal, practice, and strategic business leadership. Joining us is Matthew Leffler, the armchair attorney. Matthew's impressive career includes roles as general counsel, business development leader, and host of the podcast, Fleeting Conversations. His extensive background in employment law, coupled with his strategic insights into business negotiations, provides a perspective on how restrictive covenants are shaping the modern workforce. Matthew, welcome to the show. How are you doing today?
I'm doing fantastic, Adrian. Thank you so much for having me be a part of the program and to talk about the world of post-employment restrictive covenants, my favorite perks of the job. So I appreciate making time today to have this conversation.
Of course. So I just want to dig right into what exactly is post-employment covenants?
That's a great question. And we start off with saying, what is the nature of work in America today? Most people are what we call at will, which means you work until I say you don't work here anymore. It could be Tuesday or Wednesday, you're gone. I can't fire you for protected reasons, like if you use workers' compensation or FMLA, I don't get to fire you for doing that. But the world of post-employment restrictive covenants are exactly what we described. They're post-employment, after you've left the job, restrictive. You've given something to your employer, and it's a covenant, it's a contract. So in a nutshell, these are contracts that you give to your employer that control things that you get to do after you leave. Examples of these things include non-competition agreements, non-solicitation agreements, non-disparagement agreements, non-disclosure agreements, and increasingly a training repayment agreement plan, or a TRAP, where essentially if you leave a job, you have to pay your former company for the training that they've given you. This is what we're talking about when we think about post-employment restrictive covenants.
Wow. Okay. So I love how you even mentioned the trap analogy. It's kind of wild that some of these agreements even exist, but do most people understand what they're signing when they first go into a job? Because some of these sound very restrictive.
Let's talk about the non-competition agreements, because that is the one that is the most in the news right now. Many of your listeners have probably followed the Federal Trade Commission trying to ban non-competition agreements, the litigation around that. So a non-competition agreement is a contract that says for a period of time in a certain geography and for a certain type of business activity, you can't do it. And in America, 30 million working Americans have a non-compete. About 1 in 5 of every worker in this country has a restrictive covenant that says you cannot go work for a competitor and you may not start a business that competes with me. The vast majority of people, and this is what I do every day, they have no idea what they've signed. They have no idea what the impact is going to be. There's not a high school course in this country or a college course, except for maybe some very narrow employment courses, that would actually train you as to how to identify these things. 90% of people who are given a non-compete sign it without ever reading it or understanding it or negotiating it. They just sign it and they assume everything is fine. And it could not be further from the truth.
So Matthew, it sounds like a lot of these non-competes are very restrictive, almost like they put you into a corner and you have to sign them. So what is the solution here? How can someone actually stand up for themselves and have the non-compete maybe go in their favor?
That's a great question, Adrian. And what I would say is it really depends on where you live. Many states are regulating these things today. So, for example, In the state of California, they ban these things outright. The only non-competes that stick around in California are if you're selling a business. And if you're selling a business, you're going to have a non-compete. The buying company is not going to sit back and say, go ahead and make a competitive business. We don't have a problem with that. In Illinois, where I practice law, what we have is restrictions on income as well as really what you must do to proactively get legal counsel. So in Illinois, we require you to have 14 days to review the document, bring that to a lawyer, and even in the contract itself, it says you must seek outside legal counsel. So there are some states that are attempting to do something about this. On the other side, you have the federal government. The Federal Trade Commission, the FTC, put out a rule that was going to ban non-competition agreements across the entire country. And that ban would have been in effect as of this recording, except for litigation by the U.S. Chamber of Commerce has kind of stopped that. So really what I urge my clients to do, and anybody who's out there trying to understand this space, is you have to educate yourself. You must understand what you're signing. You must look at what the employer is asking you to do. In some cases, you don't have any time, maybe a couple of days to review. But Adrian, it gets even worse than that. Sometimes you're working at a job for weeks or months, and then they give you a non-competition agreement, and they say, sign it or you're fired. And so at the end of the day, there is a lot of things moving in this space. And so the law continues to evolve. And the best thing you can do is try to stay on top of it and have a lawyer on retainer.
Okay, wow. Now, the way it's all sounding is like a lot of these employers seem like the bad guy, right? They're the ones forcing this type of documentation and legally binding contracts onto their employees. But from the employer's perspective, what is the true purpose that actually protects them?
So what employers or hiring entities are likely to say is that the non-competition agreement protects their investment. It protects their intellectual property. It protects the secret sauce. And they're investing in you, and they don't want you to go out and compete with them. And so from their perspective, they're trying to protect their shareholders and the investment they made in you. Now, that is absolutely wrong and not real at all. We have other instruments that can protect intellectual property, like non-disclosure agreements. We can protect customer relationships with things like non-solicitation agreements. The non-compete at the end of the day is to starve competitors for talent and prevent somebody from starting a business. This is why the FTC put out their proposed rule, and that's why we saw 26,000 comments be filed on behalf of this, with 25,000 of those comments supporting the ban. It's in, like I said, every industry: doctors, anesthesiologists, nurses, salespeople in every single category. So they are pervasive and they are pernicious. The employers will continue to fight this because at the end of the day, the employers are trying to drive retention. They don't want people to leave, and they can make an option. They can pay better or have better benefits, or they can have a post-employment restrictive covenant where if you leave, they will sue you.
I see. Now, do you think that the shift to remote work has changed the way these non-competes have been enforceable or even signed? Do you think now, because work can be done remotely, there's more options, so there tends to be more favor on the side of the employee?
I think that's a really good question, and I'm not quite sure, because the remote workforce, like a salesperson's kind of a remote worker anyway. And what we see with non-competition agreements and any post-employment restrictive covenant is a forum selection clause. It says, if we decide to sue, we're suing in this state at this location. And you've consented, you've given up the right to say you don't want to be sued there. In the world of remote work, employers are far more interested in, let's call it surveillance, maybe not that. Maybe it's more like, let's just make sure you're doing okay, and monitoring your communications, monitoring the things that you do. And this is one I think is so interesting, is employers have a lot of tools at their disposal to learn about what you're doing if you're working for a competitor after you leave or whatnot. And people also love to tell the world through LinkedIn and other places, here's where I'm at now, here's what I'm doing. And that's one of the first places we lawyers go knocking on the door, is say, hey, interesting job you have there. Tell me about what you're doing.
So this is very interesting. So now we're seeing in the digital age, even social media data being kind of used in a court of law to prove that someone has gone to a competitor of a company and has basically violated their non-compete.
Absolutely. It's a great point you bring up. People voluntarily tell third parties things that they probably don't need to. And that's what social media kind of does. It teases out our ability to say, here's what I'm doing, here's why I'm doing it. And in this new age of following people's social media, we ask very specific questions of who are you talking to? When did you talk to them? Maybe not as much with the non-competition agreement, but absolutely with the non-solicitation agreement. The non-solicitation, which is not the same as a non-compete, a non-solicit is a period of time that restricts you from soliciting or diverting former employees, former coworkers, former vendors, and then ultimately the customers. You can't reach out to them. And maybe they can reach out to you, which is probably okay. But if I'm your former employer, I don't trust what you're saying. I'm going to send that cease and desist letter to you. I'm going to send the cease and desist letter to your new company. And if they don't fire you, which most of the time they do, I'll proceed to filing an injunction. And I'm going to subpoena, not you specifically, I still will, but I'll subpoena LinkedIn. I'll subpoena AT&T. And they'll give me exactly what I want to know. And if I find out that you're soliciting when you were told not to based on the contract that I forced you to sign, you're going to be in a lot of legal peril. And that is really what's at issue. It's stopping the mobility of American workers to practice their craft or to work with people they worked with in the past.
I see. Now, you mentioned the non-solicitation agreement, right? Essentially an NDA, if I'm not mistaken, correct? Like a non-disclosure?
Kind of.
Okay, what is the difference there? How are the two different? A non-solicitation agreement and a non-disclosure agreement?
So a non-disclosure is your employer coming to you and saying, hey, Adrian, we're going to give you access to some really important stuff. You're going to see the secret recipe for KFC. You're going to see the recipe for Coca-Cola. If you get that information, you can't go tell anybody about it. You can't post about it. You can't sell this to somebody else because that's my information. You don't get to take my stuff. The non-solicitation, on the other hand, is you don't get to solicit my customers to come work with you. So you can go work at a competitor. You can start your own business. I don't care. But if you're poaching my workers or you're poaching my vendors or you're poaching my customers, I will stop you and I will have the court of law issue an injunction that stops you. So the non-disclosure is about keeping proprietary confidential information secret for a period of time. The non-solicit is a do not call any of these enumerated people because if you do, we're going to have a problem. Now, those entities, those people could reach out to you and say, hey, I saw you posted a job. I'd love to work with you. That is okay. But if I'm counsel for the employer, everyone says that the person reached out. They never say, oh, no, I did. I reached out myself. So would still follow the process of identifying how that communication took place.
I see. Now, I'm hearing three important documents here, right? We were hearing the non-solicitation agreement, the NDA, and then the non-compete. When you're an employee looking to work for an employer, and they come up to you and they say, hey, we need you to sign all three. Is that seen as a red flag, or are there things that, this employee should be looking out for?
Yeah, I think that's a great question. As we mentioned earlier, there's no schools that are teaching you how to identify a non-compete. And oftentimes, they don't even call it those things. They'll call the document like an employment agreement or a non-disclosure, and buried in paragraph 13 are the post-employment restrictive covenants, the non-compete and the non-solicit. And if you get those things, the number one thing, and again, this is not legal advice, don't take legal advice from a podcast, but the number one thing to do is ask for more time. Oh my goodness, what you can do with time. Most Americans, if you said, I need $500 in the next 24 hours, they couldn't do it. And so how in the world do you expect anybody to say, I have this document in front of me, it's conditional employment, who's going to look at it in the next day or 5 days? You need to say, look, I would like to have more time. I would like to have time to review. If you get time, there's a lot of resources online, and there are all lawyers who can help you understand and navigate these things to hopefully push back. If you see all three, that's not atypical. Non-disclosures are probably in 50 to 60% of every employment relationship I've ever seen. Non-solicits are probably 30 to 40% of every employment relationship that I've seen. And my own experience is non-competes are more pervasive just because people come to lawyers with non-competes. But it's about, like I said, 20% of all workers in every working category have a non-compete. So the main thing is to buy yourself time. Then you can negotiate. You can take a pen, and the pens are really great, and just cross it out. And sometimes employers are like, that's fine. We don't make everyone sign them. So you can negotiate. You can do that. Sometimes they say no. And that teaches you pretty well, this may not be an employer that I want to spend my time with.
I see. So I'm curious, where do you see the next 5 years of post-covenant employment? Like, where do you see that going? Post-restrictive employment covenants, where do you see them developing into? Do you see them still existing? What do you think about the future?
I think the future is very encouraging. The FTC's rule, and I'll just briefly talk about this. The FTC put out a rule that's going to ban non-competes for everybody in the country, except for a couple of like key decision makers, executive officers sort of stuff. And that got knocked down in a court in Texas just a couple weeks ago. And it has to do with overruling another Supreme Court case called Chevron. The new case is called Loper-Bright. But essentially, it's restricted the federal agencies and what they get to do. But what we know is that Americans are seeing what these things actually are. States are stepping up and making actions. And so even though there's a time to be cynical and to despair, that is not this time. This is still moving. And in Congress, there's a bill out there right now called the Workforce Mobility Act. It's bipartisan support that would also ban non-competition agreements. It's stuck in committee and may be stuck in perpetuity, as bills are wont to do. But it shows that there is a trend and a force of increased mobility for workers. At a minimum, I think that the FTC or other agencies could require every employer to disclose on the job description what documents you have to sign. And that would be helpful because I think people get surprised when they're like, oh, I got a job offer. I got a new thermos. I got a cool hat. I can't wait to be part of this team. Oh, and what is this 5-page document that says I can't do my job for 18 months? I think that is what's so encouraging. And I also find venues like this, talking with you about these things, helps us educate Americans and the global workforce generally that there are things to anticipate, what to expect when you're expecting to change jobs. One thing I'll mention, Adrian, which I think is very concerning for everybody, is that nowadays, new employment relationships, like when you get hired by a new company, they are requiring the new employee to disclose every post-employment restrictive covenant they have, get copies of those documents. And the old employer, the old hiring entity, is also saying you must tell your new boss that you have this. These things are like the scarlet letter. They follow you wherever you go. And we talked before we started recording, but we as Americans conflate our identity with what we do. We are the thing that we repeatedly do. And if you can take that from someone, take away their identity, it is not an acceptable practice. And I want to see non-competes maybe not get removed entirely because there's uses that they serve, but not impact the vast majority of Americans who have them.
I'm seeing that. And you can hear it even with this litigation that's being passed and all these comments that you mentioned that were actually brought up. Over 25,000 comments for the destruction of the non-compete, or at least the restriction of the non-compete. So I'm curious, when it comes to legal professionals, how can they stay up to date with this landscape of post-employment covenants?
Well, fortunately for the legal profession, we are required to do continuing education. Every state does it differently. Illinois, we do it every 2 years. But this is an area that every single American, every client, every business that you deal with will have to wrestle with post-employment restrictive covenants. When I describe this to people who are not lawyers, I tell them it's like you're dating somebody and you're like, well, I don't think we get along anymore. Let's go our separate ways. But oh, by the way, you're not allowed to date anyone else who's like me. And if you do date someone like me, I'm going to sue you. You would say, that sounds like an abusive relationship. And Adrian, you're right, it is. And that's why we have to educate people. For the lawyers out there, this is state law, this is federal law, this is what your clients deeply care about. We need to get into a practice, I believe, where people are preventatively maintaining not just, equipment and commercial vehicles, but also the contracts that we sign. And you shouldn't sign something without having a good set of eyes look at it. A lawyer might charge you half an hour or an hour to review the document, and that is money and time well spent if it can help you prevent from getting into a situation that you cannot escape. Another thing I'll mention with those comments from the FTC, one of the things we see in America are these things called medical deserts. And a medical desert is essentially where there are no primary care physicians other than maybe the big hospital nearby. How does that happen? It happens by making the doctors and all the medical staff sign a non-compete and say, if you decide to leave our hospital and you want to practice medicine, you cannot do within 30 miles of us. And if that happens, you're in the middle of nowhere. And those doctors, they leave, they go away. So this is a problem that affects everybody at all times because it is everything. And so educating people about them is so critically important.
So I love that you mentioned how other industries are also affected heavily. Because when I hear non-competes, I think tech.
Yeah,
I think
exactly.
executives in tech, and that is the first thing that comes to mind. But with medicine, sounds like it creates a massive problem that people actually feel firsthand without actually even being related to the non-compete in any capacity, right?
Absolutely. And it gets even more depressing. I mean, if you are laid off in a reduction of workforce, your non-compete follows you. Like you have been done everything right and you lose your job and you're trying to apply for new roles. And there is a category that you simply cannot do. So this thing that we see, this perniciousness of non-competes is not for senior executives. It's for anybody at any level. I think the numbers are like 40% of non-competes are with people making under $20 an hour. This isn't fair. This is what good lawyers should be fighting against. But at the end of the day, if your client wants to find a way to drive retention and terrify workers, this is a very reasonable path.
So it sounds like there's a lot of ethical concerns with non-competes, but where is the balance? What can employers do to actually have a non-compete in place for very good reasons that they may need them? What can they have or rewrite in them so that they actually meet the demands of both parties?
I use the example of the C-suite because the C-suite has non-competes too. The difference between them and everybody else is with the C-suite, they're actually paid to sit out. You sit out for a year, you're given your salary for a year. It's not how it works for the vast majority of people. So if you're an employer and you really do believe that you need this type of protection, one way to do it is to offer separate consideration, a sign-on bonus, more PTO, things that will basically be the consideration for the contract. And I think the duration can be modified. What I see in my practice today is almost every single one minimum is 1 year long non-compete, and they're nationwide. It doesn't matter you live in Ohio or Illinois, it's entire nation. I've seen the entire globe. And so limiting the duration from 12 months to maybe 3 months or 6 months, that's more reasonable. If you're a business owner and the only reason your staff is staying with you is because they're terrified you'll sue them when they leave, you probably ought to get out of the business. Probably not a great way to do that. So there is a rationale for why you would avoid these things. You can still protect your rights with other documents. It's just non-competes are a very, very big hammer. And this problem is a very small nail. You don't need this level of control over somebody to protect your business.
I see. Now, Matthew, you speak about this very passionately, and you've had a history or really just a career in this industry. How did you first get involved to a realization that, man, this is something I really want to get into?
So I was general counsel for my family's maintenance and repair company. We had over 150 or so employees across 6 different states, and we sold the business in 2018. And as part of that deal, my father retired and I inherited a post-employment restrictive covenant, a non-competition agreement. I was legally prohibited from fixing commercial equipment for money. I couldn't do it. And when I realized that the company that acquired me was not a good fit for me, and I was about there for about 1.5 years, I had to completely reinvent myself. I had to completely redo who I was and what it was that I thought of myself. And it was some of the darkest times of my life. And I found throughout the last 5-6 years after that took place, this is a common problem. I find people coming to me on Twitter or Reddit or LinkedIn or Facebook saying, I have this thing. I don't know what to do. The vast majority of my work, Adrian, is pro bono, helping people just understand what their employer wants them to do. because they don't know how to find a lawyer. They don't got the money to pay for a review of a document. So this is why I'm so passionate. In my career, I'm 39. I've had 4 non-competition agreements. I've signed 2, and I've negotiated all of them, but I've signed 2, and I kicked out 2 others. And one time it meant me losing my job, because that is what happens in America. If you're given a non-compete and you say, I don't want to sign that, they just say, okay, get out. And that's the life that we have. Bananas. It's absolutely bonkers.
It is very much bananas, and it is just the state of our current, employment and how everything works. And I'm curious, the rise of technology, I think, has given a lot of people more tools right at their fingertips. Have you seen this be the case with a lot of these employees when they don't have access or really the funds to approach a lawyer? Are there other tools that they can use to review these documents for them?
That's a really good question. And I think that the answer is going to be it depends. There are substantial amounts of information, whether you go to YouTube or TikTok or even Reddit and you ask these questions, you can get really good feedback. You can get resources. ChatGPT can offer some level of insight, though I'll be very mindful to say us lawyers do not trust the robots. We are very clearly against the robots and we fight them. And when OpenAI started to do something that was quasi-legal, the ABA, I believe, was like, it looks like you're practicing law without a license. So there are some tools that are available, but they are variable in how effective they are. But I will say that, the tools to talk to a community of people that are experiencing similar things has never been greater. This is one of the really helpful things, is that there are millions of Americans who have gone through this same problem. Some of them have been sued. Some of them have simply been given a cease and desist. Some are just completely ignored, and they can go off and do what they want to do. So there are more resources today to educate people. And that's what my real passion is educating people on what these things are, so that when they are presented with them, or their friends or their family or their children get them, you know exactly how to approach the problem.
I see. Now, when we talk about this, we've been focusing on the US quite a bit. Is there any other country out there in the world that has seen kind of like a good model for how we should be structuring our post-employment contracts?
It's really weird. In places where you don't have at-will employment, where you're like, let's say you're a union worker in, Europe, these are not as common, but also the churn of employees is not as common. So you're not really having people jumping to different companies over their careers. In other nations, I've had people reach out to me and say, hey, I have the exact same thing. I didn't know other nations did this. The history of non-competes are fantastically interesting. They got started with, the British common law. They were out there for hundreds of years. But the story of America particularly is very interesting, and how they became so pernicious after emancipation, after the Civil War. That's when they really started to kind of get their treads underneath them and then become penetrating every single industry.
So I'm curious, the US has such a profound history with the way we do employment, right?
Yes.
And we see that creep into various industries. How about when it comes to law? You're surrounded by lawyers who know these contracts inside and out, and you have associates, different levels of attorneys coming into law firms. Have you actually found that non-competes are also very pervasive in law itself?
So, like so many things in law, the laws don't apply to us. We don't have non-competes in the legal profession. Now, that is not necessarily accurate. It is unethical for lawyers to sign non-competes. We deeply discourage them, and they are generally not enforceable with lawyers. If you're an in-house counsel for a company, you can absolutely be bound by the non-compete. But in the practice of law, generally speaking, they do not have non-competes. The doctors have them. Everyone else has them. We're special. We're magical. So we created the problem, and for ourselves, we've exempted ourselves from the problem by and large.
Now, earlier in our conversation, you spoke about how doctors can be basically a barren land. Like there's no doctors around because of non-competes. Do you think there's now the litigation that's in Congress is kind of a result of this? Like we're seeing how humans are just being citizens of the US are being affected firsthand without being related to the non-compete. Is this probably a big reason that the litigation happened in the first place?
I think that under the FTC, they had been getting these complaints for years and years and years. We have these covenants. We can't practice our craft. What are we to do? Can the federal government help us? And the FTC really studied the issue and spent a lot of time taking comments. They extended the comment period. They wanted to collect data. And ultimately, when they put out their rule, they thought that they had the authority. I think that what we're seeing now is they don't. They don't probably have the authority. Now, the Supreme Court has not weighed in, but if anyone wants to read those tea leaves, it's pretty clear they're never going to allow the FTC to have the authority to step in between an employer and their worker in 30 million instances. It's just not going to happen. So I think what we're seeing now is the trends and forces of mobility for employees is getting more interesting and more compelling. I'll give you a quick example, Adrian. So one of the ways that non-competes became pervasive in America after the Civil War was this thing called the wage contract. So someone who was formerly enslaved and had to work at a place and couldn't leave, they were now free to sell their labor. And those owners of those places were like, well, how can I stop you from doing that? How can I prevent you from going off and working down the street for more money? I don't want you to do that. And these wage contracts inserted the non-competes. And so one of the reasons we had this flight out of the South for people of color was because they legally couldn't go sell their labor the way they thought they were going to be able to do. And this is a vestige of that time hundreds of years ago. And that doesn't go away. And you look at it today and you say, well, why is it that 30 million Americans have a non-compete? It's because those hiring entities know exactly how to control you, to suppress your wages, stop you from making competitive business, and ultimately benefit presumably their shareholders. But my argument has always been, if you believe that your company is successful because you use non-competes, you will be destroyed. You will not be competitive long-term, because at the end of the day, Americans are creative. And if we know what you're doing, we're not going to let you keep doing it.
The marketplace is going to do its thing.
Absolutely. Absolutely.
Now, this is very shocking to me. I had no idea about the history of non-competes going all the way back to the Civil War. That is outstanding. And it makes me very hopeful that it will actually change, because we've seen the way that history has repeated itself, but also changed. We see what we went wrong in the past, and we're able to make deviations, so on and so forth. So for anyone, last pieces of advice before we wrap up, what is the biggest piece of takeaway if you were to tell anyone listening when it comes to a non-compete, any type of agreement they're signing, what advice would you give them to just move forward?
Do not sign a non-competition agreement. The federal government, the state government's not going to come bail you out. If you don't understand what you signed, it doesn't matter. It doesn't matter if you understand it, because if you sign it, you're bound by it. Expect to be bound by it. Again, not legal advice, not your lawyer, not attorney-client privilege. This is a separate piece of things. But the advice is, if you get a non-compete, you can find a better job. You don't need to sign it. If you have the time, if you have the resources, find an employment lawyer, have them review it, pay the fee, understand what you can and cannot do, because there are lawyers on the other side of that deal who have spent enormous sums of money building those non-competes, litigating those non-competes, and they will beat you. They will beat you. And you do not want that. So for my advice for anybody who's presented with this, if you're a young kid coming out of college and you see a great job opportunity and there's a non-competition agreement in there, pause, buy yourself time, use that offer to get a competitive offer from some other business, and do not sign a non-competition agreement.
All right. That's a great piece of advice. Well, thank you for letting our audience know. I hope really they can take this advice and take it home with them, and it'll help them in their future. Now, Matthew, is there anything you want to give a shout out to that you're doing in the future that our audience would love to tune into?
Well, if you're in the world of supply chain, you might find me in a couple of interesting things coming up. At the end of September, early October, I will be speaking on non-competition agreements at the Journal of Commerce Inland Distribution Conference in River North in Chicago. In Dallas in middle of October, end of October, I'll be speaking at the Broker Carrier Summit. That's brokerages, that's trucking companies. I will be doing an Ask Me Anything, which will be fantastic. And then finally, mid-November, I'll be at FreightWaves F3, the Future of Freight Festival, doing a fireside chat with the one and only Craig Fuller, the founder of FreightWaves. So if you find me out there, come talk with me. I'd love to talk about post-employment restrictive covenants or anything like geckos or my family or any cool, exciting stuff.
Love it. Love it. Well, thank you so much for even joining us here today, Matthew. It's been a pleasure speaking with you. And of course, to everyone in the audience that's been listening, we'll catch you on the next one. See you soon.
Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's steno.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.